A major oil company is taking on a state in a battle over climate change regulations, and it's a fight that could have significant implications. Exxon, a giant in the oil industry, is suing California over two climate-focused laws, claiming that these regulations stifle their freedom of speech. But here's the catch. Exxon, a top global carbon emitter, argues that these laws force them to endorse ideas they don't believe in. The California Climate Accountability Package, passed in 2023, mandates that large companies reveal their carbon emissions and climate-related financial risks or face penalties. Exxon's lawsuit contends that this compulsion infringes on their free speech rights, as it forces them to promote views they disagree with. The company's spokesperson, when approached for comment, directed inquiries to the lawsuit. California's governor's office, represented by Tara Gallegos, responded by expressing shock at Exxon's opposition to transparency. They assert that the laws have already withstood legal scrutiny and are confident in their validity. Exxon's lawsuit seeks to halt the enforcement of these laws, scheduled to take effect in 2026. Interestingly, Exxon already voluntarily reports emissions and climate risks, but uses its own methodologies, which differ from California's preferred frameworks. The company considers the state's methods misleading and counterproductive. The controversy deepens when considering the methodologies for emissions calculation. Exxon employs a method devised by IPECA, a global oil and gas industry association, while California's laws mandate the Greenhouse Gas Protocol, developed by the World Resources Institute and the World Business Council for Sustainable Development. Exxon's lawsuit argues that this protocol unfairly portrays large companies as solely responsible for climate change, regardless of their efficiency in meeting energy demands. Another bone of contention is the scope of emissions reporting. Exxon believes that the law should only apply to emissions generated within California, as most of its operations are outside the state. Additionally, they challenge the requirement to disclose how climate change threatens their business, arguing that this involves predicting uncertain future events. Exxon further contends that these laws conflict with existing federal securities regulations, which already govern the disclosure of financial and environmental risks by publicly traded companies. They view the California laws as an overreach by state officials, designed to manipulate public opinion and target specific private entities. However, proponents of the California laws argue that they effectively combat greenwashing by companies. Environmental advocates suggest that these disclosure requirements would expose the oil industry's biggest climate offenders. This isn't the first legal challenge to these laws. Business groups, including the U.S. Chamber of Commerce and the American Farm Bureau Federation, previously sued California over the same regulations. Although a judge initially denied their request to block the laws, the case is ongoing, with a trial expected in October 2026. The broader context includes federal efforts by the U.S. Securities and Exchange Commission to implement climate disclosure rules, which also faced legal challenges and were ultimately abandoned. This complex legal landscape raises important questions about the balance between environmental regulation and corporate freedom of speech. What do you think? Are California's climate laws a necessary step towards corporate transparency, or do they overstep the boundaries of free speech?